Accidents happen all the time. A dropped bag, a clumsy moment, just a simple mistake. But what happens when that one little mistake kicks off a bizarre chain reaction of chaos and harm? Well, that's when the law has to step in. Today, we're going to uncover the hidden legal rules that decide who's on the hook for the messy fallout of a simple accident. Okay, just picture this scenario for a second. A couple of railroad workers are carelessly trying to shove a guy onto a moving train. He drops a package he's holding, it explodes, and the shockwave from that explosion travels 50 feet down the platform and knocks over a huge, heavy scale, injuring a woman. I mean, it sounds like a total freak accident, right? A one in a million thing. But is the railroad legally responsible for her injuries? This is a real case, and the answer? Well, it opens up this fundamental debate about fairness and just how far our responsibility really goes. So, to figure out this ripple effect of harm, we have to look past things people do on purpose. Courts have a whole different playbook for these kinds of puzzles, and it's built around what is arguably the single most important concept in all of accident law: negligence. Right, so here's the thing you have to get about negligence. It's not about intending to hurt someone, not at all. It's all about being unreasonably careless. It's failing to act the way a reasonably prudent person, a regular, careful person, would in the same situation. Think about someone texting while they're driving, or a shop owner who sees a spill on the floor and just doesn't clean it up. That's the heart of what the law calls negligence. But proving someone was negligent isn't as easy as just pointing a finger and saying, you were careless. To win a case, a person who's been injured, the plaintiff, has to prove 4 very specific things. And today we're going to focus on the first and most fundamental one, because honestly, without it, the whole case just falls apart before it even begins. So these are the 4 magic ingredients: duty, breach, causation, and damages. Now, I want you to think of that first one, duty, as kind of like the gatekeeper. It asks one simple but massive question. Did the person who caused the harm owe any legal obligation to the person who got hurt in the first place? If the answer is no, then it doesn't matter how careless they were. It doesn't matter how bad the injuries were. The case stops. Right there. Game over. And this right here, this raises a huge question. I mean, if you're going to be held responsible for your carelessness, who exactly do you owe this duty of care to? The person standing right next to you? Sure. But what about the person down the block or someone in the next town over? Everyone on the planet? If we did that, the liability would be absolutely endless. So the law had to draw a line somewhere. The question is, where? Well, the landmark case that finally gave us an answer is called Palsgraf versus the Long Island Railroad Company. And the facts of that case, they might sound just a little bit familiar. Because, yep, they're the exact puzzle we started with. So here's the play-by-play of exactly what went down. You've got these 2 railroad workers. They're trying to help a man get onto a train that's already moving. They kind of push him from behind, and in the process, he drops the package he's carrying. Now, nobody had any idea, but inside that package were fireworks. It hits the tracks and explodes. The sheer force of that blast travels all the way down the platform and topples a heavy set of weighing scales, which then fall on Mrs. Helen Palsgraf, injuring her pretty badly. So she sued the railroad. This case was so tricky, it went all the way up to New York's highest court. And once it got there, it sparked one of the most famous judicial debates in the history of American law. It was a battle of ideas between 2 absolutely brilliant judges, Benjamin Cardozo and William Andrews, who had totally different views on where you draw that line of responsibility. Judge Cardozo, who wrote the opinion for the majority of the court, came up with this incredibly elegant and powerful sentence. The risk reasonably to be perceived defines the duty to be obeyed. It sounds a little fancy, but what it boils down to is this. Your legal duty only extends to those people you could reasonably foresee hurting with your actions. So, applying that logic, Cardozo argued that the railroad owed absolutely no duty to Mrs. Palsgraf. And why not? Because she was what he called an unforeseeable plaintiff. She was standing way outside the zone of danger of the specific careless act, which was just pushing a man onto a train. Nobody could have reasonably predicted that pushing a man would lead to an explosion that would then injure someone so far away. The chain of events was just too bizarre. Now, this is where it gets really interesting, when you put these 2 views side by side. Cardozo's view, which is now the majority rule across the U.S., says that duty is relational. It only exists between you and the foreseeable victims inside that zone of danger. But Judge Andrews, in his dissent, argued for something totally different, a duty to the world.
He believed that if you act carelessly, you owe a duty to anyone who gets hurt, period. For Andrews, the whole foreseeability question should come in later to decide how much you should pay, not to decide if you owed a duty in the first place.
Okay, so we've established that there's a duty not to carelessly harm people who are in a foreseeable zone of danger. But that brings up a whole different question, right? Do we ever have a duty to actually help someone who's in danger? And this is where the law can be, well, pretty shocking. The general rule in common law is that there is absolutely no duty to rescue someone. I mean, you could literally be an Olympic swimmer, see a toddler fall into a shallow pond, and legally, you don't have to lift a finger to help. The law has traditionally valued individual liberty, the freedom not to act, over forcing people to get involved. But, and this is a huge but, that startling rule is immediately followed by some really critical exceptions. The law will force a duty to help on you if you're the one who created the danger in the first place, even if it was a total accident. You also get a duty if you voluntarily start to help. For example, if you pull someone from a car wreck but then just leave them on the side of the road in an even more dangerous spot, you could be liable. And finally, a duty exists where there's a special relationship, like between a parent and a child, or a business and its customers. So, what's the big picture here? What does this all really mean? It means that the law is in this constant balancing act between responsibility and personal freedom. It draws a line in the sand, that zone of danger we talked about, to stop the ripple effect of one accident from creating an infinite amount of liability. So, all of this really boils down to two key principles you should take away from this explainer. These two ideas pretty much define our legal obligations to each other when it comes to accidents.
First, the duty not to harm other people through your carelessness is limited. It's not this giant blanket duty to the entire world, but a focused one that's owed only to foreseeable victims inside that zone of danger. And second, the duty to help other people is even more limited. In fact, it pretty much doesn't exist at all, unless one of those very specific exceptions we just talked about applies.
So at the end of the day, in the case of the exploding fireworks, the court drew a line, and Mrs. Palsgraf was on the other side of it. They said the railroad was not responsible. They decided that foreseeability was the best tool we have to define the limits of our duty to others. The law drew that line, but the question that lawyers and philosophers have been debating ever since is the same one I want to leave with you. Is it in the right place?